for myself and my clients. The reason for that is if I'm drafting a contract for a business, and the other side is thinking about whether or not they're going to breach that contract or dispute the terms of the contract, they have to know, okay, is Josh going to litigate this, or is other people going to litigate this? What court are we going to be in? What's likely going to be happening with it? So the fact that they know HSK through its good reputation and having a strong litigation team, they're going to know that we're going to be able to effectively litigate the terms of the contract and possibly prevail. So at least it's important for them to know that there's a good litigation team standing behind the contracts and documents and other things that have been drafted. So that's why I mentioned that at least. But we think integrity is very important for our firm as well. So we work hard to do a good job and do things the right way. All right. Well, first, I wanted to mention this. Why do these things matter? And because each of these mistakes that we're going to talk about are going to be fairly serious or can be significant to the company. In some situations, it could be fatal and could cause a loss of revenue, time, and other things that's going to interfere with the business. So my approach is to try to educate business owners of these issues, the relevant risk, and to help take steps to avoid them. There are a lot more than 10 potential business mistakes, but these are the top most common ones that I see in my practice. And I've been doing this now for a long time. I was licensed, as I mentioned, in 2001, and this will be going on my 24th year of practicing law and doing this. So let's talk about number 10. Number 10 is making things too fancy or complicated. What do I mean by that? It comes up sometimes where people think every type of entity has to be a Delaware corporation or Nevada LLC or done in some other jurisdiction and state or Wyoming. Indiana has good laws for both corporations and LLCs. In addition, I've seen people where they've had just when they're starting up or even really new entrepreneurs having too many legal entities, separate legal entity for its every revenue stream or something like that. It can be complicated in some situations for them to manage that well. For business owners that own rental properties, it's not uncommon for them to have multiple LLCs if they have several properties, but it's not necessary for an LLC to be for separate LLC for every residential real estate property. If it's a multi-tenant, that's a different situation. But oftentimes I see where people make things just too complicated. You have to be registered with the state to do business here in the state of Indiana. If you're a foreign business, it must be registered to do business in Indiana as well. If you fail to register your entity, you may be restricted from utilizing the court systems or going through the court systems to enforce contracts or to take other legal action. Delaware entities are very expensive, and litigation in Delaware can be very expensive as well. They have a court of chancery. And so there is some expertise that's developed there that's commonly used for publicly traded entities. But for Indiana, we've developed a fairly significant amount of expertise as well. We have commercial courts now set up here in Indiana as well, at least here in Allen County and in some other counties. So it's important at least that we look at, are there good laws? And are they built on common sense and sound public policy? And LLCs and corporations can and do protect people as long as they're operated prudently and appropriately. Having too many legal entities can create confusion and can create risk. I've been involved in Chapter 11 bankruptcies where there were multiple entities and they were transferring money from one entity to another all the time without any real rhyme or reason, and that created problems for the bankruptcy courts and jeopardized the corporate veil. So at least the KISS principle is that keep things simple, and that's appropriate when you can. There are times when it's appropriate to get things more complicated, but they don't necessarily need to be initially, and this may not be appropriate. All right. Number 9 is not having good or adequate insurance. There are lots of different types of insurance that are required for an entity. As you can see from the slide, it has property insurance, liability insurance, commercial auto insurance, workers' compensation insurance, business interruption insurance, health insurance if you want to provide that for people. And the newer one that has to be considered, especially if you're doing a lot of things online, is cyber protection insurance. Cyber protection insurance is a type of insurance that may provide coverage in the event that the company is hacked improperly, or that there's access and confidential information becomes public when it's not supposed to be made public. So there are different types of things that you have to consider as to what the value of the appropriate amounts of the insurance is, and whether you need all of these types. There's going to be some differences based on the type of business you have. Another item would be commercial umbrella insurance. Commercial umbrella insurance would be an excess insurance policy for any type of liability that would go beyond the amounts that we're talking about on the general policy. I've been involved in some contracts where we've had cyber policies with coverages up to $5 or $10 million. That may be enough, that may not be enough, depending on the situation. So it just depends on what information you have, how it's stored on your system, and the likelihood of a risk in the risk that will be present in the event of a breach. The commercial liability umbrella policy provides the extra layer of liability protection by covering costs that go beyond your other liability coverage limits. In other words, commercial umbrella insurance complements your other liability coverages and takes over when your other liability coverages limits have been reached. Number 8, failing to protect confidential information. The need for confidential information continues to grow, and the need to be able to protect it. Confidentiality agreements are legally binding contracts in which a person or a business promises to keep specific information of another person or business confidential and not disclose the secrets without permission. There can be limited exceptions, and they should be narrow exceptions. Normally, those type of exceptions relate to in the event of litigation or an order from a court or other governmental entity requiring disclosure. It could be if the information otherwise becomes public or as otherwise disclosed, or it could be other things. Trade secrets also have to be kept confidential. Trade secrets are an important and valuable asset of a business. In Indiana, trade secrets are protected by the Uniform Trade Secret Act, pursuant to Indiana Code. Trade secrets are generally defined as information that derives its independent economic value from generally not known or readily ascertainable information and data, and reasonable efforts are instituted to maintain their secrecy. Businesses must be vigilant in maintaining the secrecy of their trade secrets. The failure to maintain proper mechanisms to protect the business's trade secrets could potentially limit the business's rights to pursue former employees or that violate or disclose trade secrets or use confidential trade secrets or other information. And there was one individual I met when I first moved to Fort Wayne a long time ago, and he's quite the character, but he was working with a company, and one day I was out to lunch with him, and it says, "See this, Josh?" And he pulled out a thumb drive. He said, "This is my insurance policy." I said, "What do you mean?" He said, "If I get fired from my current employer, this has all their trade secrets and all their information, and I'm going to take it to their number one competitor and go there the next day." And I was flabbergasted. I didn't say anything specifically about it at the time, but I just was thinking, that that's the type of thing that the businesses have to protect against and make sure that not everybody has access to all their trade secrets and confidential information, and make sure it's restricted and properly protected. Number 7 is not having appropriate employee policies and procedures and an employee handbook. An employee handbook is an important part, and it provides a standardization of personnel and benefit policies, preventing misunderstandings, complaints, and job dissatisfaction out of misinterpreting of rules or things of that nature. I mean, there's could be questions all the time. What happens if people show up late or tardy? What's the policy for when somebody wants to take time off work? What's the policy for seniority status, or let's say if there's disciplinary issues, is there a progressive policy, meaning that you're first going to get a written warning, then there's going to be a meeting or a probationary period or before being terminated, or is it a verbal warning, then a written warning, then is it that somebody's subject to termination, or things of that nature. It brings uniformity across the company to have the policies. It explains the expectations for everyone and mentions the consequences of violating the rules by explaining the workplace ethics and expected behavior with colleagues and those in management. And employee handbook minimizes workplace disputes. If you have at least 15 or more employees, you have a section that's going to talk about discrimination, sexual harassment, and all those type of areas too. Different federal laws kick in at different numbers of employees. So that's why those would be looked at as well. Having the policies and procedures helps in the event of a dispute. If somebody claims that they were discriminated against improperly or acted against improperly, if you have an employee handbook, written policies and procedures to show, no, we followed our policies and procedures, it helps protect your business. If you have written policies and procedures, but you don't follow them or don't keep them current or don't utilize those create other issues on their own, because if you get into a litigation where somebody said, I feel like I've been discriminated against, and then at cross-examination at a trial or a deposition, they say, you have policies and procedures in your company, correct? Yes, I do. What's your policy and procedure? You lay it out. Was that policy and procedure followed? No, it wasn't in this case. Why wasn't it followed in this case? And that just looks very bad and creates other types of issues. So you want to have policies and procedures in place, but they should be kept current and be effective in order to protect and help your company. Other policies can be on work schedules, leave, compensation and benefits, dress code, performance reviews, salaries and pay revisions, holidays, training, termination, and a lot of other things. It reduces some time at the beginning too, or could reduce some time when they're onboarding, because they can go ahead and review the different documents instead of being trained on all of them. But they just, one thing I will also suggest is if you have policies and procedures, you want to generally email them to everybody, just so they're readily available. And you can have and should have them sign for it, not only to say that they acknowledge that they received the policies and procedures, and that way they can't later on say, well, I didn't know we had policies or procedures, or I never received the policies and procedures. So by having them sign for it, you can help establish that, we have policies and procedures and you signed for them. Okay. Generally, having the policies and procedures will help keep a company in compliance with federal and state law to the extent necessary as well. And it will help a company come forward with its stand on issues like favoritism, discrimination, harassment, and also provide information on how to report any violations regarding such issues. It can also include a whistleblower policy or retaliation policy. All those types of things could be considered and discussed, depending on the size and needs of your business. Number 6 is compliance. The law changes frequently. So it's very important that you keep on top of the different requirements. I looked up recently the number of pages of federal regulations. In 2018, there were 67,000 pages of federal regulation. In 2019, there were 70,000 pages of federal regulation. 2020, it increased to 71,000 pages of federal regulations. In 2021, it was at 74,532 pages of federal regulation. And I think that they still only had, going up to 2022, counted where that was about, if I remember correctly, 80 or 90,000 pages of federal regulation. So if I wanted just to read all of those pages of federal regulations, I could divide that by 365 to see how many pages I'd have to read a day just to stay on top of it. Unfortunately, not all of them are going to relate to business, but a lot of them will. So just as important for us to stay on top of them. I have had a big issue that we were dealing with this year is the Corporate Transparency Act. The Corporate Transparency Act was passed became effective on January 1st of this year. And it required businesses to file the beneficial ownership information report with a FinCEN, which is the Financial Crimes Network of the Department of the Treasury. So at least in that situation, it was the general gist of it was if you had a business in existence prior to January 1st of this year, you had until December 31st of this year to file your business entity report, or pardon me, your beneficial ownership information report. For new businesses this year, you had 90 days from the date of the organization or incorporation of your business to file it. So I had one person that filed it on his own without knowing about this, and he blew by the 90-day time period. And then another 180 days went by, and he called me up when he found out about it because he was freaking out, saying, Josh, what's the penalty for failure to comply with this? And it's potentially up to $500 a day. He did the math, and he was potentially at risk for up to $90,000. He said, are they going to send me a bill for $90,000? And we at least put some thoughts together and put some documents together and some other information. I noted what he attempted to do and tried the steps he took to mitigate everything. And we got the report filed for him as soon as we could. So all those things were now in place at least. And I don't think that they're likely to go after him for it. The one issue that we just had recently come down is earlier this month. There was a temporary, what we call preliminary restraining order or preliminary injunction that prevents the enforcement of the Corporate Transparency Act and businesses having to file uh, the beneficial ownership information report. You still can, but you're not going to be fined or penalized if you don't do so. So there's going to be a question as to what the effect of this is going to be in the future. So the way I would explain that is that it's on pause now. It's not gone away because they're still litigating, and there's actually been an appeal filed as well. So the federal government's position is that the Corporate Transparency Act is valid and enforceable and effective, and it's just being paused currently. So they're going to come back and say, okay, everybody that didn't file theirs has to file theirs now. But other people I know are still filing them. I filed one yesterday for a business just because they wanted to go ahead and get it filed, and not have to worry about following the litigation and filing it at some point in time in the future. So in addition to the pages of federal regulation, we have state statutes, federal statutes, state regulation, and state local laws and ordinances. So the amount of information that people have to stay on top of it is getting higher and higher. And with regard to the Corporate Transparency Act, I have people ask me all the time that weren't familiar with it. How am I supposed to know that? Is the federal government going to send me a letter or notice? And the federal government doesn't do it that way. They publish notice in the Federal Register, and that's deemed to be a proper notice to everybody. So they don't send a separate letter to everybody on all the registered businesses around the country or in our state. So everybody has an obligation to be informed of the laws and to stay on top of it, or to work with their attorney to do it, just so we avoid fines and other issues. The Corporate Transparency Act is just one example, but there are others. But that's the current one that we have been getting most of the questions about. Number 5, not protecting the brand, legal name, or intellectual property of the business. This is one that comes up fairly frequently. There is a school here, a university called the University of St. Francis, and we've had business competitions and training meetings over there for business owners. And one time we had where a group of people were working together at a table and coming up with a business idea and developing intellectual property. Then halfway through, we had one person grab the intellectual property from that table and take it to a different table. And so they either have to start over or modify the intellectual property in such a way that would allow the company to continue. That happens. And when we talk about intellectual property, we're talking about things like copyrights, patents, and trademarks, certainly. But we're also talking about the brand. Trademarks are normally used to help identify the brand. And the legal name of the entity. That could be the actual legal name or assumed business name. One thing that I see all the time is people not using the full legal name. I have people say, well, do I have to use the LLC or the LLP or the Inc? Because I don't like how that looks. And generally you do have to use those because you have to put people on notice that you're a business and operating as a business. You can otherwise do that by using an assumed business name. There was one matter I was involved in where a guy was an auctioneer in the state of Indiana. Then when things got going really well, he went down to Florida, figured he could make some more money down there, and was doing things very well. He set up an LLC down there, decided on a name. And then during the Great Recession back in 2008, he ended up moving back to Indiana just because there were too many issues going on in Florida and he was having problems. But he didn't register his Florida LLC to do business in Indiana. That would have cost him, I think it was like $35 at the time to register his entity here, just so he could protect it and use it going forward. Instead, he saw somebody else, and somebody talked with him. Hey, I really like your name. How did you come up with that name? And he went through the whole story about how he came up with the name for his business. And the very next day, he received a cease and desist letter saying, I've registered and protected that name here in the state of Indiana. If you try using that name at all or anything similar to it, we're going to sue you and get an injunction to stop you from using it because he didn't take steps to protect that name here in the state of Indiana. So other things to think about would be inventions, literary or artistic works, designs, symbols, logos, names, all of those types of things have to be protected. We already mentioned trade secrets, how those are important to be protected. It's important to do due diligence in an effort to avoid infringing on someone else's trademarks, patent, or copyrights as well. So you can't, but equally, or if not more important, is also just making sure that you're protecting yours. Both of those are important issues. Number four is not having good contracts and having contracts annually reviewed. How many contracts does a business usually have? They normally have several. I mean, we're going to talk about sales contracts, service contracts, leases, licenses, franchise agreements, loan documents, financing documents, marketing contracts, contracts with your vendors and suppliers, contracts with your customers, all types of contracts. And normally a contract is one thing that provides a lot of lifeblood and the revenue for your business. So having a good contract and making sure the contracts are clear and unambiguous is real important. It's also important to have provisions regarding what happens in the event somebody breaches a contract. Is there an attorney fee clause? Is there clauses for late fees or interest that would be due? What about in the event of litigation, where is the litigation going to be held? What type of law is going to apply? This becomes particularly important for e-commerce businesses. E-commerce businesses would be somebody that just is selling their products online. And if somebody is a relatively small business and selling their products online, somebody buys it in California and is unhappy with it or gets injured by using their product, if they file a lawsuit in California, then that's where they would potentially have to defend the lawsuit and incur a lot of cost and time. Even a frivolous lawsuit is going to take a lot of time and expense and be a major distraction for the business. So at least by having good contracts and putting things in the contract, you're able to provide more protection for the business. Having the contract signed, electronic signatures are now fairly well accepted. So there's federal laws and Indiana laws that allows for electronic signatures of contracts. There has even been contracts that can be made now via text messages or emails. Those things are all valid ways to enter into contracts if the terms are specific enough. The basic components of a contract is that there has to be an offer, there has to be an acceptance, there has to be mutuality and consideration. What that means is if I want to sell somebody my pen, I have to I can make an offer to sell my pen. Somebody has to accept the offer to buy my pen. We have to have mutuality where we have to be talking about my pen. Somebody can't say, oh, I want to buy your tie instead because I've not offered to sell my tie or I've offered to sell my pen potentially. And consideration just means there has to be an exchange. I have to give you my pen in exchange for something else. That could be cash, or maybe we'll just trade pens or do something else. But there has to be what's called in the law a quid pro quo. I give you something, you give me something. And we can agree on what the value of that is. This could be my favorite pen. So that could be a very valuable pen to me, where it's not not a great pen for you. So those are all things that would have to be considered and decided to determine. As long as those elements of the contract have been satisfied, and that could be through text messages or emails or other things, that can form a contract. But it's much better and cleaner to have a clean written contract with very clear terms that can be signed either electronically or by a wet signature, that then you can present to the court in the event of a breach to help file the lawsuit and enforce it. It makes things a lot easier. And having the contract reviewed annually is appropriate just to make sure it stays current and up to date. We talked earlier about how the law changes frequently, and there are different things that happen. So it's important to make sure it's kept current. A couple other things I'll just mention is websites should have good terms and conditions.
And I think that is
terms and conditions of use would be information about what's going to happen when they use the website, how are they allowed to use the website. And there's two different types normally recognized. There's a click wrap and a browse wrap. Click wrap is where they have to click that I agree to the terms and conditions. Like if you go to buy something through Amazon or another website like that, you normally have to agree to their terms and conditions when you're purchasing something. When you have to click something that's saying, I agree to the terms and conditions, that's generally known as a click wrap. The browse wrap would just be a situation where you're agreeing to be bound by the terms by your use of the website. Oftentimes people will be using the website without being aware that they're being made subject to their terms and conditions of use by simply using the website. Click wrap is the preferred way just because it's easier to show that they're aware of it and that they agree to the terms. Privacy policies are becoming more and more important as well these days for websites. Several jurisdictions require privacy policies, and there are different issues that have to be considered about privacy policies. This could be whether or not you're collecting information and what information you're collecting about individuals and users of your website. So it's just important to be aware of those issues. Okay, number 3, I'm not preparing a succession or exit plan. This is a fairly common legal issue that I see as well, and a legal mistake, because there's in general, there are good ways to exit a business and bad ways. Normally, the best ways to exit a business is by sale of a business or a planned transition or a voluntary liquidation of the business. That's not often the best, but it's still an okay way of doing it. The bad ways of doing it are a receivership, bankruptcy, or an involuntary dissolution or dissolution of your entity. So the way this comes up oftentimes, if it's for small businesses, it may be that we just have one individual that's the owner of the business, in which case the plan may be, who do we want taking over the business in the future? And how do we want to put that provision in place? In Indiana, we can use a transfer and death description for units of ownership. We can also do that for shares of stock for corporations, and units of ownership are for LLCs. You can also have Indiana law now allows you to specify who you want your LLC to go to in your operating agreement, or it could be in your last will and testament. Indiana's trying to make it easier for somebody to take over and continue on the operation of the business. But it's something that should be thought out and considered and discussed. The data historically has been that 70 to 80% of the businesses failed to successfully transition from the first generation to the second generation. And the second 80% or 70 to 80% of the second generation failed to successfully transition to the third generation. So it's very important at least to have a succession plan. A succession plan doesn't guarantee the business is going to do well and succeed, but it certainly increases the likelihood of success. If the goal of the business is to sell the business in a short term, it's best to start that plan at least 18 months to 3 years in advance to get things squared away and have things in order. Just because there's a company I was working with here in Fort Wayne, Indiana, that a company from Connecticut was coming to purchase. We have a fairly standard amount of due diligence that we typically do here in Indiana and the Midwest. But this company, being from up in Connecticut, was doing its northeastern amount of due diligence, which got to be pretty intrusive. It was they were asking for all types of information. We were almost waiting to see if they were going to ask for employee underwear size and color. It got to be so intrusive. And anytime things weren't exactly the way they wanted it to see it, they would blow up. Oh, this is the worst deal ever. This is horrible. This is going to create all types of problems. But we'll feel better if we renegotiate the price a little. So oftentimes they just would look at anything and everything in an effort to try getting the price reduced. So by having plans in place and doing things and putting documents in order in advance of putting it on the market will help. Other types of things that we like to see planned for would be any types of incapacity, such as somebody becoming disabled, potentially somebody developing Alzheimer's or dementia, potentially going through a divorce. Do we want the half of the business to go to the spouse or ex-spouse in that situation, or other types of issues? We have to think about, as I mentioned already, the death as well. When somebody passes on, who's going to take over that? So there's a number of things that have to be considered and evaluated as part of the plan. It's just important that you consider those type of issues. Let's go on to number 2. Not properly forming a limited liability or corporation. I see individuals that set up LLCs or corporations on their own or through LegalZoom and all these other places and they don't have them done correctly and aren't doing them properly or aren't doing it carefully. I had one company that wanted to form an LLC, went to the Secretary of State's website, and they ended up forming a limited liability partnership, an LLP instead, and didn't know the difference at first between the two. And so I had to explain the situation to them and talk with them about it. I've had people, one guy, I think it was earlier this year, a few months ago, that came in and said, Josh, I have my LLC, and I was talking with him about it. He ended up having a sole proprietorship. Then he formed an LLC, but he never was using the LLC. He was still operating the business as a sole proprietorship, never had any money going through a business bank account, never was doing anything through the business. So the LLC wasn't providing any protection for him. And he just didn't know that he needed to operate the business through the LLC. members don't often pay attention to the different elections that they have to make, whether it's such as for how it's going to be taxed, or whether it's going to be manager managed or member managed. And oftentimes people aren't aware of the differences between those things. Those are different types of situations that I see quite frequently. Members not being intentional about determining the number of units. Normally, depending on the situation, if it's a small, closely held business, we may just have 100 units or 100 shares of stock. But for other situations, we may do 1,000 or 10,000 units or 10,000 shares of stock. There would be different reasons for doing different things, but those should be thought about carefully and intentionally. I have people that often will just pull up for LLCs an operating agreement online and think that any operating agreement will be good for them. But operating agreements are best when they're customized and fit your company's specifically. I've had people that have had operating agreements that they've referenced California law for Indiana entities. An Indiana entity shouldn't have California law referenced in the operating agreement. Similarly, shouldn't have Florida law or some other type of law. In that situation, it just led me to believe that they ended up going online, finding an operating agreement, and deciding that they were going to use that for their entity. One question I often get is, do single member LLCs need to have an operating agreement? And they really should. They say, well, who's the agreement between? The agreement is between the LLC and the one member of the company, because LLCs are different persons under the law. For corporations, we want to make sure that they are going to have a proper board of directors, have bylaws in place, be familiar with the number of shares they have issued and outstanding, and being intentional about those issues and who's the shareholders. And for both LLCs and corporations, they should maintain the corporate records and company book and have annual meetings. All right, and the number one issue that comes up that I see is not treating the business as a business. Under the Indiana law, a corporation or limited liability company is a separate legal person under the law. It's separate from the business owners. This is true for large and publicly traded companies and for small ones, even if it's just owned by one individual. The business accounts and the personal accounts of the owners must be kept separately, as well as for the business property must be kept separate from private property. I often have people ask, what difference does it make? It's all my money. But that's not correct. The LLC's accounts or the corporation's account are subject to claims for creditors, other vendors of the business, or other people that the business owes funds to. It's only your money once there's been a distribution made or salary paid to you. Distributions made to owners that render the business insolvent render the business owner personally liable in Indiana. So it's very important to not just take all the money out and deplete things, and to treat the business as a business. The purpose of setting up a corporation or LLC is to reduce the risk of the owner's liability and protect personal assets. In other words, I incorporate or organize an LLC or corporation to help the individual start a business, but it's a way to minimize their legal risk. Indiana encourages entrepreneurship by permitting individuals to set up corporations and LLCs to operate the business and reduce personal liability. The risk is that if the owners do not treat the business as a separate business, the courts may disregard the business or of the LLC or the corporation. That's known as piercing the company veil or alter ego type of liability. Both of those allow the assets of the owner of the business to be at risk and to pay for the debts of the corporation or LLC. So there are different situations. One example I'll give, there was an excavating company I was working with a number of years ago, and they came to me after a lawsuit was filed against them. It was a significant lawsuit. It was filed against them, and a judgment was obtained against them. Then they said, Josh, we got this judgment against our company. Can you protect our business? At that point in time, it's a little late to try protecting the business. You have to do it beforehand. Indiana looks at a number of different factors. We look at specifically at 8 different factors to determine whether or not to pierce the company veil. This guy was doing 7 of them. He was undercapitalized. He had some assets of the business in his personal name, some assets of the business in his business name. He was paying his mortgage out of the business bank account directly. He was doing all different types of things that prevented him from, he wasn't treating the business as a business. And his comment to me was, Josh, how was I supposed to know I'm supposed to do this? I'm just a guy that knows how to do an excavating work and will set up my business. And the law presumes that he's going to know or get educated about that or work with a licensed attorney to help him. So the factors that Indiana courts look at is whether there's an undercapitalization of the corporation, meaning was there sufficient money that was invested in the business initially to protect the business? The absence of corporate records, where there are proper records or documentation in place. Fraudulent representations by the corporation, shareholders or directors. Any type of fraud will create risk and issues. Number 4 is the use of the corporation to permit fraud or injustice or illegal activities. The simplest example would be if somebody starts using their entity to sell illegal drugs. If they're selling illegal drugs, the use of the entity is not going to be sufficient to protect them from either potentially criminal or civil liability. Number 5, the payment by the corporation or individual obligations, such as in my example where the guy was using the company business account to pay his mortgage bill directly, as opposed to paying the funds properly. Commingling of assets and affairs, not keeping separate accounts. I've had to have some people in some businesses. I said, okay, to make it easy, let's have your bank for your business account thing, be at bank Y, and for your personal assets, bank X. You can have them at the same bank as long as you treat them and keep them separate and distinct enough. But for some people, if they can't do that easily, it may be helpful to separate different banks. The failure to observe required corporate formalities is number 7. And number 8, this is a catch-all that is used in Indiana, other shareholder acts or conduct ignoring, controlling, or manipulating the corporate form. So that just could be any number of different things that the courts could consider. For LLCs, it's the same factors that we end up looking at. So successor liability would be when there's fake or fictitious transfers. If we have a company saying, okay, I'm just selling all my assets or my company now to Joe Smith for $1, and then Joe Smith takes it over, and that's going to be a fake or fictitious transfer and isn't likely to be sufficient to protect the company and its members or shareholders. The key to think about is if you don't treat the business as a business, why should your creditors treat the business as a business? Or why should the IRS treat the business as a business? Or why should the courts treat your business as a business if you're not protecting it and treating it as a business? The business must be conducted in the name of the business, meaning in the actual name of the corporation or LLC, and contracts must be executed in the name of the business and not in a personal name. I see that mistake often as well. So from a legal perspective, I wanted to share this document with you as well. This is just how we view risk management. We would look at different, you can look at structural risk management, you can look at compliance risk management, contractual risk management, and litigation risk management. These are going to be different issues, and there's going to be different things we can do to help different situations, at least as we're looking through that process. But it's just important to keep in mind because we're trying, the goal that I have is helping entrepreneurs and business owners manage their legal risk and do it well so that the business can be profitable and successful. And this is a disclaimer just to let people know that this is not is information of general nature, not intended to be specific legal advice. And we're going to see if there's any questions that you have, but it's going to be recorded and it's not subject to confidentiality. So this isn't the way that we're going to create a legal relationship. If you have specific questions that need to be addressed or you need legal advice, it's best to contact me offline just to make sure we can just see if it's something that we're going to work together on, and just so you have complete confidentiality and are able to get the advice that you need. Again, my name is Joshua Burkhardt. This is my contact information, and thank you for your time and attention. Bill, I'll turn it back over to you if you'd like.
Things that maybe we can address. One was, is an employee handbook required if all the employees are?
I can't hear you, Bill. I heard it. Is an employee handbook required? Is that the question?
Yeah, if all the employees are contracted.
Oh, if they're all contractors. Well, if they're all independent contractors, then an employee handbook wouldn't be applicable to them because you're either going to be having employees or independent contractors. You can have like a vendor or independent contract standards as well that you're going to have in place, which would be similar, but it's not the same. The law makes a clear distinction between employees and independent contractors. And I will share briefly that the law has been shifting more and more to make more and more people employees instead of independent contractors. The federal Fair Labor Standards Act and under the IRS provisions, all of those things are making it harder for somebody to be an independent contractor. So you have to verify that it's really truly an independent contractor, but then you wouldn't have an employee handbook for them, but you could develop other policies and procedures that you would have in place that could be similar, but it wouldn't be the same.
We had one other question about what's the difference between LLC and PLC?
It depends on your state and where you are, because Indiana doesn't have PLCs. But I mean, generally that is sometimes that means like it's a professional type of business and has certain other protections under the law. So in Indiana, we have like a PC and just standard corporation. So it would be a similar distinction between that, where a PC is a personal corporation, where normally that's a business that's going to provide personal services. And they have some distinctions under the law as to how it's different from a standard corporation. There might be a little bit of easier record keeping requirements, or maybe easier in some other respects, but generally it's going to be very similar in how it's operated and how it should be managed and run. I'm not familiar with the jurisdiction you're in, or why what your state would have for PLLC. But I mean, I would look into that, at least if you're interested, just to make sure you understand the difference and see if that's something you should take advantage of.
Another comment was, are charging order protection better in Wyoming and Delaware?
Charging orders, let me explain what those are briefly, at least with, in general, if somebody is an owner of a limited liability company, let's say it's my favorite three guys, Larry, Curly, and Mo, the Three Stooges, own an LLC. And one of them is driving by and runs over the local brain surgeon or somebody else and gets a huge judgment against them. So it's beyond the amount of liability protection provided by insurance. So then they're knocking on the shareholder's door and saying, or the member's door and saying, what assets do you have to pay for this liability? The charging order protection is to try preventing it from having a situation where they seize somebody's units of ownership and take over and become a member of the company. The charging order is supposed to act as a garnishment of that member's units and may allow for them to obtain a percentage of the profits and revenues of the business, or a percentage of the ownership distributions. So it provides protection in that regard. If we had a corporation, for example, and it doesn't have charging order protection, so potentially a creditor could seize the shares of stock and become an owner of the entity. LLCs provide protection against that by having charging order protections. My understanding is, and I've not compared the law in Delaware and Wyoming recently, but based on the research I've seen in the past, it appeared that Wyoming had slightly better protections for charging orders. But several states have modified that to provide for more protection for for members of LLCs. The key difference is if you have a multi-member entity, the charging order protections make a lot more sense than if it's a single member LLC. And the courts are much more apt to provide charging order protection for multi-member entities than they are for single member entities. Because if I'm the guy that drove over the brain surgeon and severely injured or killed him, and I'm the sole owner of the LLC, then the charging order is just protecting the negligent guy, me. So in that situation, the courts are somewhat reluctant to provide full and complete charging order protection. It seems like some states still do, but it's unclear as to what extent. So multi-member entities generally have a bit more protection and are a little bit easier to protect in that regard.
Another question, should a lawyer draw up privacy policies and terms and agreements for a website, or can it be done by the business owner?
It should be done by an attorney. I mean, the business owner can potentially do it, but I mean, it's best if it's done by an attorney. We have experience in drafting contracts, and one example I'll give was I had a guy that was opening up a gym membership. He worked on his gym membership agreement, and he worked on it for 35 hours, he told me. And he asked me to review it quickly, thinking I was just going to be able to say it looked great and give it back to him. It looked terrible. He cut and pasted things from all over. It had inconsistent terms, and it would not have been easily enforceable or a good document for him to use. I told him I can draft a contract, and after taking a couple hours, that would look professional and be more enforceable. And he ended up agreeing and letting me do that. Um, I just think it's a better practice because at least the contracts I put together are going to be much better and much clearer than the contracts I see other people put together on their own.
Another one, do sole proprietors need to file for the BOI?
Do they have to file for a beneficial ownership information report? Sole proprietors do not. If you don't have to
Okay.
file something with the Indiana Secretary of State or the Secretary of State in your jurisdiction that set up the entity, then you don't have to file the beneficial ownership information report.
Well, there's several more questions, but we're 8 after now, and we're supposed to be done by 1. So I think perhaps we should drop it off. You've got Joshua's contact information. If you have further questions or you need to follow up on a specific individual problem, please do so. Again, thanks, Josh, for your continued support of SCORE.
You're welcome. SCORE is a wonderful organization, and I'm happy that everything you guys have done, and it's a wonderful group of people.
Okay, thanks everyone for attending. And we'll
Thank you.
send out a copy of the presentation and the recording.